All right, everyone, we're going to get started. It's a little bit past 7, so we're going to get started and jump right into it. I woke up with a sore throat, so hopefully it's not too distracting. I have my hot tea with me, but I'm so excited because this webinar is going to be so much full of information. I hope you have like your writing pads and your notes ready to go because I'm so excited to give you all this information. I'm trying to jam pack it into one. I really feel like this could be a series because there's so many things that a trustee needs to do. But hopefully, I'm not expecting you to learn everything about a trust administration, but if you can just kind of remember little bits and issue spot, I feel like that is going to be really helpful for you. If you are a trustee or if you have set up a trustee and you're wanting to tell them what to do, doing the trust administration, it's really not simple. It's not like a, step one, do this, step two. It's not really like that. It's more about like understanding the process. So this is what I'm going to be going over for today. All right, so let's get right into it. And I first want to do a quick introduction about our firm. And we practice exclusively in estate planning, probate, and trust administration. Like that's all we do. Even though we have a background in a lot of different types of law, I think it gives us an advantage to kind of help you plan and talk with clients. But really, we want to focus in and we only do estate planning, probate, and trust administration. We are in Cerritos and Mission Viejo. So this is related to California law. If you are from out of state or wondering if this can apply to other states, no, this is for a California law, this presentation. So just letting you know about that. And we are a women and minority-owned firm, and we can help clients in Spanish and Korean. That's a little bit of introduction. And me here, oh my gosh, it's like I already have 18 years of trust in the States experience. Time flies, doesn't it? And I received my undergrad from UC San Diego, seems like a long time ago, and my law degree from the University of the Pacific, McGeorge in Sacramento. But I'm local, I grew up in Cerritos, I'm currently living in Cyprus, and I can help clients in Korean. This is my partner, Stephanie Rales, and she has also been in only exclusively in the area of probate law for about 14 years now. And together we have a combined, what is that, like 32 years of experience between both of us, only doing estates and trusts. She went to UC Irvine and fourth in her class at her College of Law. So she's a little smarty pants there. And she's really, when you work with us, you have the benefit of having 3 attorneys, actually. We have Jenny Ravelli, who is also our trust administration attorney, who also assists. And Stephanie grew up in Laguna Niguel and still lives there. That's why we have an office in Mission Viejo. We just want to give a quick disclaimer, of course, like this is just very general information. It's not like very specific. There's no attorney-client privilege here. I'm not like your attorney based on this. Of course, every different administration is different, right? So just take this with a grain of salt, and please don't record or anything like that without permission. You could take a screenshot just for your personal use, but I don't want to see anything like posted on social media about this presentation or anything like that. I do record this. It's on my YouTube. If you don't have that link, you can go to our website or ask me. So all my previous webinars, if you've missed it, you can get it through YouTube. And just want to put in bold, like this is just general information. Like there's so many different types of trust administration. This is really focusing for estates like 5 million or less. If you have more assets that you're managing, this is not for you. You have to take like way extra steps, right? And I'm also just giving the highlights of the administration. Of course, I can't go to like every single detail. I'm just trying to pinpoint like what are like the high level overview highlights. It's definitely not a complete list of actions. Please consult your attorney, financial advisor, or tax professional. Okay, so all that out of the way, what is a trustee? Because the presentation is about understanding the role of a trustee. And here, a trustee is a person who's managing assets for someone else, otherwise known as a fiduciary, a person whom property or power is entrusted for the benefit of another. And this trustee is managing a trust, and they have the legal obligation to administer it not for themselves, but solely for the beneficiaries and the purposes specified. So this little comic is like, turns out fiduciary means you have to give it back, right? He's like in jail. He used it for his own purposes. So you can't do that. It has to be for the benefit of the trust beneficiaries. And to kind of go along with that, the trustee has certain duties that are imposed by law that they have to adhere to, or else they could be personally liable too. So they're very strict. You definitely want to pick someone who you trust and also who knows what they're doing, in a sense where they're not going to just like, oh, I don't know what I'm doing, but like someone who will, take that obligation and work with an attorney perhaps, or follow the terms of the trust. So just to clarify a little bit of what these words mean in terms of like trustee, executor, administrator, because I feel like some of these words are used very loosely to say, oh, I'm an executor, I'm like a trustee or something like that. But for an attorney, when I hear the word trustee, I know that there is a trust. And I know that this person has the authority to conduct trust business. When I hear the term executor, I know that there is a will. So the executor is not for a trust, executor has to do with the will. And when I hear that, I'm thinking, okay, this person is not here, because a will is not valid when you're alive, right? A will is only for after you're not here. So then when I hear executor, okay, this person, somebody who must have died, and maybe they're in probate or something where the will is like now taking action. If there is no will and it's in court, then the person appointed is called an administrator. And then a general kind of overarching term for all of these is a personal representative, a representative for the person. Okay, now this is like a really, really high level view of what is trust administration, because now you've set up your living trust. Excellent. This is when you're alive, you made this plan, and then now you're not here. So what is the next person going to do? Well, in a nutshell, what they're trying to do is take assets from the one who died. And the trust is kind of like the middle part where they figure out, okay, is there any taxes to pay? Did they have any creditors? Like, trying to figure this stuff out, settle the estate. And then eventually it's going to get distributed to the beneficiaries. You see why the trust is so important. You can't go from like someone who passed away directly to that person. There has to be some kind of middle administration to figure out, is there taxes owed, like who gets what, like all of these questions that need to be answered. So this is kind of the flow. That's like what you're trying to do. And this is also another high level view, carrying out the terms of the trust. When you are a trustee, I like to think of it like you are a trustee employee. It's not your money. You're handling things exactly like what the trust says, and you're just carrying it out. You cannot make changes to the trust. That was for the person who passed. Only they can do it. But now if you are the trustee, okay, what's the last version of the trust? And you're just carrying it out. And by carrying it out, you have to take certain steps. First, and I'm going to go over these really like in detail, but first you have to send out notice. Like people have to know, okay, someone passed away, there's a trust, they have to know this information. So definitely you need to send it to the beneficiaries and heirs. I'm going to get to distinguish that in just a second. But this is by law, by probate code. That's what PC stands for, probate code 16061.7, you have to send out notice. You can't just be like doing your trust administration and nobody knows like what happened. They've never seen a copy of the trust. Like you can't do that. So that's why if you're a beneficiary and you're like, I've never even seen a copy of the trust, like I don't even know what's going on. Yeah, you can demand that from the trustee, and that's something that you do have a right to see a copy of the trust. You also have to let the government agencies know, of course, the franchise tax board, right? They want to make sure the taxes are paid. And Medi-Cal too. If it turns out that they used Medi-Cal benefits when the person was alive, Medi-Cal might want to get reimbursed. So that's a whole nother topic that we can get into. And creditors, yeah, people who are owed money. Obviously, they need to know when someone has passed that if they're owed money, they can submit a claim. And the next thing that a trustee is going to be doing is once they've sent out notices, they have to gather or marshal trust assets. What does that mean? They have to find the assets, right? They have to figure out like, maybe they have to call like a bank. They have to check the credit report. Maybe they have to look through tax returns. Maybe they look through the files, check the mail. They are, sometimes I've had clients hire a private investigator if they don't know the trustor, the one who died, if they don't know them very well, they can have maybe a private eye kind of figure out, okay, what assets are we talking about? There are some companies also that like specialize in finding assets for you, but you're going to have to, look through the mail, like I said. Maybe there's unclaimed property that the state is holding, right? So these are little things where we have to uncover. You have to write letters to the banks. The banks can't just give information. They want to know, okay, like, do you have authority for me to give this information to you? We have to write them letters. And once you figure out those trust assets, we need to do an inventory and maybe an appraisal, right? Because, for example, if your trust says, 50-50 to the two kids, how do you know what's 50-50? So you might have to appraise certain assets to figure out, okay, what is the valuation of that? So we have to figure out what is the inventory. And you might have to change the trustee because of death. Because remember, all of these assets are going to have the person's name who passed away, the decedent, also known as the trustor. It's going to have their name on it. Obviously, they're not here. They can't sign over anything. They cannot transfer anything. So you may have to change that name to you under your authority as the trustee of the trust. So that type of like change needs to be made. It could be done in the form of just presenting the death certificate, copy of the trust. In the case of real estate, you would have to file a deed that says a change of trustee that has to be recorded. And you can also consider selling or liquidating assets, right? Sometimes there's like stocks, sometimes there's like, what other type of assets? You want to consider, should I sell it and liquidate it? Or can I transfer it, like a rollover directly to the beneficiaries? These are things that we need to think about. And then, of course, you have to pay the bills, right? If you have like a real estate, and you're probably not going to transfer it to the other person like the next day. It's probably going to take some time for you to like find out the assets, do the taxes and all that stuff. In the meantime, right? Property taxes probably might need to get paid, like utilities. Is there a mortgage, right? So you need to have that authority and access to the bank accounts to be paying these bills and creditors. The other thing that a trustee needs to do is filing and paying taxes, right? Of course, if there's any income that's generated, and other types of taxes we'll talk about, they have to figure out those taxes. Um, the last two things is a trust accounting. This just means, okay, what is all in the trust, right? What went in, what went out? They have to account for that penny because it's not theirs. Remember, it's the funds are someone else. So imagine if you were a beneficiary, someone else is handling your trust, you're just waiting to get paid out. Wouldn't you want to know, okay, what wasn't there in the beginning? Like, did you take the money out? Like, what did you use it on, right? So that's what the trust accounting is for. And then lastly is the distribution. Now, this distribution, it depends on what the trust says. Does it say they just get it right now? Do I hold it in trust till you reach a certain age? Like, all of this will depend on what does the trust say. But if you think about this, everything that you're doing, I feel like we're doing this right now when we're alive, right? Like we are paying the bills, we're filing taxes, we're kind of keeping an inventory. So the trustee is really stepping into your shoes to kind of settle things for you. So that's the role of a trustee. So let me just jump back to the notice part. And this is like right at the beginning of a trust administration. Like this is one of the first steps that I do when I first get a case that's a trust administration case. Trust administration, meaning that someone, the trustor, the one who set up the trust, passed away or they became incapacitated. Either way, if they cannot act, somebody has to act for them. Side note, that is the beauty of a trust, right? It's like if you can't do something, you've already set up a plan where the next trustee can do it for you. If you didn't have a trust, like if you don't have a trust right now and something happens to you, like who's the next person who has authority to like handle your bank accounts and sign things, right? That's why a trust is important. All right, so this is the first step in a trust administration. What is this notice? What goes in it? It's information about the trustee, right? They need to know, well, who's the trustee? Who's handling this? We need to write that down. Okay, well, was there a trust? Like, what are the terms, right? I mean, we need to know that. And of course, did somebody pass away? When did they pass away? Like, And where is the place of an administration? Where can I contact you if I have like questions or need to know something? Here we will put the place of administration and the contact information. This is also important because if the beneficiary wanted to bring a court action, they need to know what county and where to do the court, right? They can't just file an action anywhere. They have to do it at the place of administration. Who gets this notice? The beneficiaries and the heirs. What's the difference between a beneficiary and an heir? An heir is like your next of kin, right? So I guess it would be, if you're a person and you're married, it'd be a spouse, kids, right? And then kids of kids. And then it would be parents, siblings, nieces and nephews, so forth. But there is like a tier. So it's not just like everybody, it's kind of like who is the next in line. And beneficiaries, these are the people that are named in the trust who actually get funds. You see how they can be different, or maybe they're the same. For example, I have 3 kids. I only want to give to 2 of them. I don't want to give to the third. You can see how the third would get notice as an heir, but they are not necessarily getting anything from the trust as a beneficiary. So that's an important distinction. Why is it like that? Because it's just to prevent, what if the person who passed away was under some kind of fraud and they like got their trust redone and nobody knew about it, right? The heirs would want to know, okay, like, is this a legit trust? Did they get like fraudulently, swayed into like signing things, right? So that this is why it's important for the heirs to get notice. And when the trust becomes irrevocable, which usually will happen at death or incapacity. Why? Because at death or incapacity, that's when the person who set up the trust, the trustor, they can't make any more changes. They can't manage it anymore. And that's why you're giving notice that, oh, someone else is taking it over. This notice is very important because it sets up 120 days from the notice date that someone can contest the trust, which means that if you never send out this notice, I mean, technically, I guess they could contest the trust like any time. And you don't want that. You want to give them a certain amount of time so that, oh, you have a problem with the trust. You think it was done fraudulently. Maybe it was done like an undue influence. Somebody like forced them to do it. Maybe the trustor didn't have capacity to even sign this trust. Maybe they got swayed by like a caretaker or something like that. You have 120 days to contest the terms of the trust. And after that, whatever the trust is, that's the set terms. And at this point, you do have an option to give a copy of the trust or not. And it extends if you do decide to give a trust copy, it extends this 120 days. But this notice is going to be so important. Okay, so the next thing, once you've given out notice, you need to start marshaling these assets. And these assets will be in one of 4 categories. Hopefully, the person who passed away did all their homework and everything's in the trust. Excellent, easy. We just like handle things in the trust. If they had an account that's a joint account, all right, it just means that it goes to the other person. If they had an account that was a beneficiary or TOD, it would go to that beneficiary. And if they had an account that was only in their name, then we might be in probate. So let's go into it. A trust asset, like real estate, it's so important to title it in the trust. You might have some bank accounts, maybe life insurance, all titled into the trust. And when it's in the trust, we have to think about, okay, do I just give the asset in kind? Do I have to think about property taxes, capital gains taxes? These are all things to consider. I guess the example would be, there's one piece of real estate, 2 kids, 50-50. How do you transfer that piece of real estate, right? So just thinking about, do they buy each other out? Do they both put each other's names on title? Is there any property taxes to think about? If an asset is a joint asset, or maybe there's like a beneficiary named, then we have to remember the assets go to that joint account holder. This is important because when you're planning beforehand to set up the trust, like clients say to me, oh, my daughter is a joint account holder with me on a checking account, right? It's good because if something were to happen, they're the joint account holder, co-owner, which means they can sign things, but you've got to remember if I pass away, it all goes to that other person, meaning they may or not, give it any to their other siblings, right? So, and if that's the case, the other beneficiaries could say, look, mom only put you there as a joint account holder to just help with like bills and stuff. That should not all go to you. That should go into the trust. You can see how there's a potential for litigation there. There's something called a Hegstead petition where you could actually grab an asset that's not in the trust and put it into the trust if there's evidence that it's supposed to be in the trust. But if not, then that is a separate asset away from the trust. Now, this is where you might get in trouble because you might have an asset that is only in the decedent's name. This means that even though you have a trust, you could still be in probate. It happens all the time, unfortunately. So I had this case where the client had a trust, but he did it like 20 years ago and he totally forgot about it. And he got this new property, forgot to put it in the trust name. And it was a piece of real estate, not in the trust, no indication in the trust that he wanted to put that asset in the trust. And we're doing a probate. So this $184,000, it kind of depends on whether it's going to go through a full probate or what I call like a shortened or mini probate. Did you know that there was a new law that it was enacted just this month, where they changed the probate laws just a little bit. If you do have a primary residence, and that's like pretty much all you have, and it's less than $750,000, then you can do like a shortened probate. You still have to go to court. It is still probate, but it's going to be a little bit of a lessened or shortened probate, not like the full blown, like 2 years, like crazy amount. So there is some relief if you do have a very small estate. But again, this does not eliminate the need to do a living trust because you're going to still be in court, which means that, and just a little quick difference between trust administration, what we're talking about now, versus probate. Probate is you're going to be in court, right? And it probably takes about 1.5 years, 2 years for probate. It's super stressful. Who wants to be in court? And yeah, we're trying to avoid that by having everything in a living trust. Okay. I think we talked about this. Okay. Considerations when I'm thinking about assets. If it's a rental property, there's income that's being generated. We want to think about where does that income go? It's going to be in the trust. And if you have tenants dealing with the tenants that are in the rental property, you may have to update those rental agreements to be now you trustee of this trust, right? Because if the house is a trust asset, obviously you are going to be handling those tenants. This is important because, again, if you need to evict somebody or you need to deal with them, the person who did is not here anymore. So then who has authority to like deal with these tenants? That would be the next trustee. If you do have a business, right? Hopefully you did an assignment to assign that business interest into the trust before death, because if you have a business and the person is not here, who has the authority to sell it, transfer it, close it down? No, who's going to sign these documents? So it's really important to set up an assignment to assign that business into the trust if you do have a business. All right, going to taxes. I know we're moving so fast, but when I think of trust administration, I'm really looking at these 4 taxes that are really kind of in my mind when I think about this. The first is property taxes. If you do own real estate, I'm really hyper-focused on, I don't want a reassessment. What are some ways that can keep the property taxes low? I'm also thinking about estate taxes, capital gains taxes for real estate or stocks, and income taxes too. These are kind of like the 4 taxes that I'm thinking about. Let's start with estate taxes because that's kind of easy. This amount changes every year. For 2025 right now, we're at 13.9 million per person. I know you guys just missed it, but it means that if you pass away with under this amount, then you don't have to pay any estate taxes. It's per person. So if you're married, you have 28 million about to have in your estate without paying any estate taxes. Awesome. But this amount does sunset at the end of this year. Now, we do think that it's going to probably continue on because this is under it was first enacted under Trump, and obviously he's president now again. So I do think it's going to keep going. But again, who knows? We don't know. Anything could happen right now. And so we're going to see where I know the estate planners are watching this very closely to see if this number is going to change. If it does sunset or expire, we think it might go down to maybe $7 or $8 million, but we will see. If your estate or the assets under the trust, if you feel like it is a little bit, maybe not quite 13 million, but pretty high up there, you need to file a tax return within 9 months. It's called the Form 706. This is especially important for married couples because you have to elect something called portability, which I'm not going to get into right now, but it's important not to miss these tax deadlines. And interestingly enough, there are no death taxes in California. Not yet, I should say. And property taxes. This is also what I'm super hyper focused on. Property taxes if you own real estate. Anytime there is a change in ownership, a death would be a change in ownership. The county is like, how can I get more taxes? And they want to reassess this property to today's value, right? So you know that under Prop 13, your property taxes just go up incrementally, right? It's not like nowhere near the value of the current property right now. But if somebody died, they're going to try to reassess it to today's value, which is probably going to be really high. So I'm looking for exclusions. The most common one, of course, is the parent-child exclusion, which otherwise known as Prop 19. There's also exclusions for tenants, co-tenants, if you live together and you're both on the title. And there's others too, which we could go into in another time. Prop 19, they changed this law about, 4 years ago now. This is the rules in a nutshell. You have to have been living there before you passed away, so the primary resident of the decedent. It has to be the primary residence of the child now. Now, if you have 3 kids, and let's just say only one of them is going to live there, it does qualify. They do have to file a homeowner's exemption form within 1 year. So you can see there's these deadlines that are happening. You do have to act quickly if you are a trustee and there's been a death. And one thing I didn't note is this is for values only up to $1 million. So if your residence is going to be more than that, that part of it does get reassessed. Here is a common issue when there's only one real estate. Do I sell it? If I one real estate, maybe 2 or 3 beneficiaries, right? If you sell it, it's easy. You don't have to think about property taxes, net proceeds divided, awesome. But what if you have, one person who lives there and they're like, I don't want to move. I want this property. Then do you put all siblings on the title? If you do, the other 2, they'll never get to really do anything or see that inheritance. Their name is just on title in equity. Maybe that's okay. Maybe the one who lives there has to pay them rent. I don't know. These are things to consider. The other thing is, okay, well, maybe the person living there has to buy out the other siblings. Okay, well, how much? And when? When is this all happening, right? And anytime you do any kind of buyout, you also want to think about property tax issues. You can't just get a mortgage and pay them out. That might cause a property tax reassessment. So you need to talk with an attorney about possibly using a trust loan. You also want to think about capital gains taxes. Oh my gosh, these too many taxes. Oh my gosh. But this is a question I get daily. And in fact, just today, I got the same question again. Do I give my properties to my kids right now, even while I'm alive? Or should I wait till after death? And for me, it's better to get it as an inheritance for tax purposes. Why? Because you get a step up in tax basis for capital gains. This means that when you pass away, now the kids get it. If they go to sell it, they're calculating the capital gains from the date of death, not when the person first bought it way long time ago. But if you give the property right now, then there's no step up. The child, let's say you pass away, you guys are both on title. It doesn't matter if the child then goes to sell it. They have to calculate these capital gains from when you first bought it way back when. So in terms of capital gains taxes, it's always better to get it as an inheritance. But there could be some other circumstances, so to consider, not just taxes. Lastly, income taxes, right? If the trust was getting income, You want to file a tax return. Maybe they have a rental property. Maybe they have stocks that were like generating interest, right? Maybe you had to liquidate something and it generated some taxes, right? We want all these things. Of course, they want their taxes paid. The government wants taxes paid. And when it is the first year after someone passes away, you do have to do their final personal tax returns. So let's just say they passed like in April. Then you would have to do their final personal tax returns from January to April under their social security number. And then after they pass away, you can't use their social security number anymore. So you got to get a trust tax ID number to go from, let's just say it was April, they passed away April to December. Any income that's generated would be on a trust tax ID. So, oh, and one thing to note, everybody has like brackets, right? For trust, for income taxes. The trust is always going to be taxed at the highest tax bracket, right? But usually beneficiaries are, and regular people are on a lower tax bracket. And if that's the case, then you might be able to flow some of that liability, tax liability, to the beneficiaries on a K1. That means the trust doesn't pay taxes, but the tax liability could go to the beneficiaries and they would have to put it on their tax returns because they're usually going to be at a lower tax rate. So that's some kind of strategy that you might be able to use. Now, I did have a client once where there was like 20 beneficiaries and like all of them were like 80 years old and they were getting government benefits and all this stuff. So at that point we were like, you know what, maybe let's have the trust pay the taxes, even though it might be slightly higher, and then the beneficiaries don't have to worry about it. So really want to think about what's the situation here. And administration expenses are deductible, something that you'd pay the attorney, maybe compensation that the trustee would get, those could be tax deductible. You're also going to do a trust accounting, right? So now you file the taxes and now you have to figure out, well, what's all in this trust? And you have to put what are the beginning assets, what went in, what went out, and what's at the end. And here I like to do a distribution, a proposed distribution. So I like to present this to the beneficiaries. Okay, this was what, and now here we are at the end. And this is like the breakdown of what I think everyone should get. I usually like to send this out to the beneficiaries. And when you're figuring that out, you can think, okay, well, do I get any compensation? I mean, I feel like this was a lot of work, right? Being a trustee, right? Thinking about the taxes, marshaling assets, a lot of things to do here. You can consider a compensation, but it depends on what the trust is. I did read this trust once where it was like, no, the trustee gets no compensation. So you want to be careful about reading that. Again, everything is really going to be, what does the trust say? Okay, and that's why everything I'm telling you could be different because it depends on exactly what are the terms of the trust. But generally, if you do have any reimbursements, money that you spent out of pocket, you can get reimbursed, some expenses. But when you figure out this accounting, you want to send this with very specific language in the probate code. Why? Because it sets a 3-year statute of limitations to bring an action. It's kind of like you send out this accounting, and there, if you have a problem with it, you have 3 years until you can bring an action, and otherwise you can't, bring anything up again. So there could be some issues like that too. And these are some strategies that I like to use. This could be different for any firm or, any trustee, but I like to think about the timing of the distribution, when to give the money, right? Because remember in the very beginning, we had to give that notice for 120 days to contest the trust, right? If I give the money out too early, what if they use the money to hire an attorney and then sue me, right? So it's not that I'm like holding the money hostage. And usually this administration will take about a few months, but we kind of want to think what would be the timing of when I can give this money. Another thing to think about is if I give the money all out right now, what if I get like a huge medical bill or like a tax bill later on? I'm not going to have any money left to pay all that. So I really want to make sure everything's like settled until I'm ready to make this distribution. You can also do something called preliminary distributions where it doesn't mean you have to give everything all at once. Maybe you can just do like a little bit at a time. Sometimes to just like keep the beneficiaries like, okay, like don't worry, like a little bit is coming. you can do that too. Preliminary distributions, all of that does need to be recorded, or not recorded, like logged, right? Keeping track. You can give distributions in kind or liquidate. So for example, if you have like tax stocks or something, do you want to just roll it over, or do you want to liquidate it? And if you do liquidate it, is there going to be some taxes? Did it go up? Is there like a gain? Or maybe it went down and you can use some of that, the loss in your taxes. So things to consider for that. And for me, I like to have them sign a voluntary release. So it's like when I give you the money here, like sign this release that the trustee did everything, like you're cool with it, like this is all the money you're going to get. It's voluntary. You cannot hold the money hostage. You can't say, okay, sign this and you can't get the money. You can't do anything like that. But if they voluntarily sign it, all good. And you do want to hold a reserve, like I said, for unexpected expenses that might pop up, right? Because once you give the money out, it's really hard to get it back. So you want to hold a reserve. Talking with the accountant, kind of seeing like, hey, well, do you anticipate any taxes to be paid? And lastly, we could petition the court to approve the accounting and distribution. So if I feel like, okay, if I give the money out, again, they might use it to like sue me, or they're not they're disgruntled, I might just ask the court to approve that accounting so that we've got a court order, this is done. These are some duties of the trustee that you have to think about. We have to administer the trust. You can't just be sitting on your butt, right? I had a trustee once, like they came to me after 5 years. I was like, what the heck are you doing, right? Like you have to keep things moving. You also have a duty of loyalty to the trust and the beneficiaries. You have to deal with them impartially, including yourself if you're a beneficiary, right? Which means avoiding any conflict of interest. If there's like a piece of real estate and you're like, I really want that, but I don't want to pay full price, and can I get a discount? No, like you have to have no conflict of interest, be impartial, and always act with the benefit of the beneficiaries. You have to take control of and preserve trust property. You probably heard like as soon as someone passes away, everyone comes into the house, they like take stuff, right? Well, if you're the trustee, you might have a duty to preserve those trust assets. Maybe you have to change the locks. Maybe you have to put like, cameras up. You have to maintain that trust property. You also have to keep it productive. If you are managing a trust for minors and you can't give the money out until they're age like 25 and they're like 8 years old right now, you do have to make that productive. Maybe it means investing that money wisely, nothing crazy, so that it's generating income and being productive. If you have a vacant house and it's going to be there for a pretty long time, maybe you have to rent it out and let it be productive. You have to keep the trust separate and identified. Do not make the trust bank account your bank account. Do not use trust funds for your own personal things that you're going to get in big trouble. Do not do that. And of course, providing information to beneficiaries. I mean, all the time they're like, I don't know what's going on with the trust. Like, I haven't heard anything. You have to provide information. And typically in trust, they do say you have to do an accounting every year. So make sure we review those trust terms. Does the trustee have to accept his or her role? This is like a lot of information. I don't even know if I want to do this now, right? So no, a trustee can accept or decline this responsibility. Just because you name someone doesn't mean they have to do it, right? But your trust should have language that, okay, if somebody resigns or if there's a vacancy, how is the next person going to be appointed? Does the last person get to appoint somebody? Does the court have to appoint them? Does like a majority of the beneficiaries decide who's going to be the trustee? Those are things that a trust should have. Did you know that you can also have a professional fiduciary be a trustee? For those clients who maybe they don't have kids or they really don't want to put this type of burden on anyone, they can have a professional be a trustee. This is called a private professional fiduciary. They are licensed by the state of California. They're licensed, they're bonded, they got insurance, and this is their job, to be a trustee all day long, right? So if you want, you can name them. The good thing is that they don't charge anything until they actually have to do the work, and it's typically hourly. So let that be an option. And you can also have co-trustees, which means that you could have two or more people be this trustee. There's good stuff and bad stuff about it. So if you're thinking about that, let's have a talk about that. The successor trustees have to serve during incapacity and after passing. I once reviewed this trust, and it was done by one of those paralegals, and they did not have an incapacity clause, which means that they did not have a section where what happens if the person, who writes the trust, what if they become incapacitated? What happens? So that is so important to have that section in your trust. First of all, who determines incapacity? I read this one trust where it was like, oh, my brother will determine if I'm incapacitated or not. What? I mean, yeah, I guess you could put that down, but like, what if he's like, oh, you're incapacitated? Like, that could happen. Usually in my documents, I say that 2 doctors have to say you can no longer handle things. Then the trust becomes irrevocable because now there's no one else to manage it, and the next successor trustee will be the one to manage things. So usually at an incapacity and after you're not here, that's when the successor trustee steps up. If you have an older trust and you are married, this is something to really think about and review your trust. Back in those times, when the tax laws were a little bit different, it was really common for married couples to do what's called an AB or ABC trust for tax purposes. It means that when one spouse passes, the trust would be split into 2, and the one who's alive has to do all of these things. It's like a mini trust administration. They have to like divide it. They have to get a separate tax ID number. They have to split assets, and it gets a little bit complicating. But now, because the tax laws are so high, like the 14 million that I was telling you about, now, it's not necessary to do this for tax purposes. You still might do this if you have children from like a prior relationship that you kind of want to save half of the trust for. But again, if you are married and you have kind of an older trust, then you need to get it reviewed and see if you have this split that's in the trust. If you do and you pass and they pass away, there's certain ways around it, but if you can get that updated now, that would be awesome for the next trustee who's got to manage it. And again, as a trustee, do I have to hire an attorney? Seems like a lot of steps. Technically, no. You can do it by yourself. You're not required by law to have a trustee, but you can see that there's a lot of things going on. And if you have a lot of assets, you feel like there's going to be some tax liability, maybe you think there's some like a potential for beneficiary disputes, then yeah, you probably need an attorney to kind of guide you, make sure you're doing it okay. And does the trustee get paid? Seems like a lot of work. Yes. The trust terms will typically outline how much you get paid, but if it doesn't, then the probate code says it's reasonable compensation. Why don't they just put like an hourly rate or percentage? Because it's all different, right? Like, what if I was the trustee, an attorney, versus like, someone else who may not have that experience, right? You can't charge the same compensation. Or a percentage, like how much is the estate worth, right? 1% of like $1 million versus like, 10 million bucks. I mean, it might make a difference, right? So you want to think about all these things to think, okay, do I get paid? Plus, if you do get paid, you have to report that as income on your tax return. So how can I avoid probate, right? Because right now I was talking about after death, not going through the courts. All of this is really paperwork that I'm showing you. You don't have to go through court, thank goodness. But if you did have assets that are not in the trust, you do have to go through probate, which is going to be my next seminar in June. It's going to be about the probate court process. If you didn't do your trust, and if you don't have any, trust administration, trust assets, then what? What happens? I will go through this probate court process for my next seminar. But I thank you so much. We already are at the end. We made it. I'm trying to keep this 45 minutes. I know you probably have a lot of questions, but I thank you so much. Contact me afterwards if you do want to set up a time, if you have questions. Otherwise, this is recorded, and I thank you so much for attending, everyone. Have a good night. Thank you.